Okay, hi, and welcome to the Law Simplified. I'm Shaveen Bandaranaike. First and foremost, a quick apology for what happened earlier. I'm just trying to get this platform up and running, and I think there's a little bit of latency going back and forth. I hope that you are hearing and seeing me clearly, although there might be a slight delay depending on where you're watching this. Um, Bear with me since this is the very first session as well. There might be a few things here and there that we might need to work out essentially. But having said that, welcome to the very first live stream session for criminal law in terms of the Law Simplified, and I thank you for joining us today. Let's give about a minute or two so that we have a few students joining in. As we go along, I've essentially outlined a way that we're going to conduct this session, and we're going to test out a few formats today, so that then as we come back to different sessions across the next several weeks, we'll be able to hone in and get the right format that we can go for. I already see a few questions coming in. Once again, bear with me. In terms of the structure of how we are going to do this, by and large, how I essentially wanted to go about it. Let me just get my slides up real quickly. Essentially, the way that I wanted to go along with it was to start off by looking at the subject itself very broadly, looking at the different topics essentially. We will, if we have time, go through a question as well, where we look at and try to break down a common question specifically in relation to homicide, because that's one of the areas that are predominantly tested. And in terms of structure and what you will usually notice, you'll see that the format that you implement for something like homicide is what you get to see in other areas as well, at least the structure when it comes to the introduction as well as the rest of it from the breakdown perspective. So we'll look at a question breakdown at that. Once this is done, we will go through a quick Q&A. Rather, half of our session will be dedicated to questions and answers, because I'm sure a lot of you do have questions and answers. And the very reason that this particular session we are having is because we are at a very uncertain time frame, in the sense that you know what's going on globally. And as I mentioned when we began this session as well, as much as you can study and you can prepare for law in your own time, in solitude essentially, the prevailing conditions are not apt to discussions and throwing or back and forth ideas with one another. And law is much more enjoyable, and you develop better techniques of argument, and you're able to articulate your thoughts better when you bounce off said ideas with others. So the idea is to have a community built up around these live sessions, so that you can ask fundamental questions as well, and we can learn from one another also. Okay, so I do see a few concurrent viewers joining us, but before we proceed, let's give them a few more minutes just to join in. And we'll begin by looking at a few theory lessons, or in terms of the different topics, and I'll give a broad outlook so that you understand what this subject is about. But in the interim, make sure that just so that I have an idea of what we need to go through towards the latter part of this session, make sure you use the chat box, which is available on this very platform itself, since we're going on YouTube. Make sure you use the chat box to put down any questions that you have in relation to, it might be theory, it might be applying theory to a particular question. It might be in general when it comes to an examination technique even. Make sure you check out some of the different videos that are on this channel itself. There's a lot of rich content in terms of what I've done over the past several years, different techniques when it comes to examinations, different techniques when it comes to studying and preparing for different topics and different subjects at large, as well as specific theory content for each individual subject. So make sure you go through those once this session is over as well. Right, so we have several people coming up already, so let's let's sort of jump into it. And obviously, if there are those who are joining us in between, they can always join us for the questions, for the Q&As. Okay, let's begin by, let me go into our very first circuit. Right. So generally speaking, one of the major topics when it comes to criminal law is that of homicide. Now, homicide, by and large, encompasses what we call the poster child of criminal law. This is the very first topic that most of us go through, and it provides us the basis and the fundamentals of pretty much every area that we'll go through thereafter in this subject. As you know, criminal law deals with what we call, or what I like to refer personally as, a one-to-many relationship. So what a one-to-many relationship means is it's something that is established by a government, a state, and those rules or those offenses, as we call them, are essentially applicable to everyone and anyone, regardless of whether you choose to be bound by it or not. If you're a citizen, you're bound by it. So you have one superior, one government, or one entity that makes these offenses, that defines these offenses, and those are applicable to pretty much every single person in the same equivalent way, as we'd like to call it. The burden of proof in terms of criminal law is beyond reasonable doubt. And the reason for this is because the outcome of a wrongful decision is something that you cannot take back. The purpose of criminal law, by and large, is to punish an offender. So because it is to punish an offender, it's either in some cases life imprisonment, or in other cases it might be the death penalty. Because of that, it's very difficult for us to take back a decision that's taken. So unlike in contract law, for example, where the standard of proof is a balance of probability, in criminal law, what essentially happens is the standard of proof amounts to beyond reasonable doubt. Every single element of the definition must be complete in order for a person, an offender, to be charged and later convicted and imprisoned. Now, having said that, there are essentially several topics, several offenses that are covered in a majority of syllabuses in general. The most heinous or the most extreme offense at that is homicide. So homicide, the easiest way to identify homicide is if you have a dead body. Homicide relates to a person taking the life of another unlawfully. So it's essentially the unlawful killing of a human being with an intention to kill or cause grievous bodily harm. So this requisite physical component of killing someone, as well as wanting to do so, the intention to do so, culminates in the offense of murder. That is the highest offense of homicide. When we talk about the different offenses under the umbrella of homicide, you have murder, which we just outlined a moment ago, and voluntary and involuntary manslaughter. So voluntary manslaughter is essentially the same outline as murder, except the mens rea is qualified in some way. This qualification of mens rea amounts to a situation where, yes, he admits that he did unlawfully kill a human being, which is the same actus reus, the physical component of murder, but the mens rea is qualified due to a pre-existing situation of his history, of his mind, in the context of diminished responsibility, or what we call as crimes of passion or heat of the moment. Something that made him or her lose his control at that very moment. So the question here is not whether he is denying that which happened is right or wrong. Rather, him suggesting that, yes, I did it, but it is mitigated because of X, Y, or Z reason. So that's why we call it as a qualified reason. Now, mind you, I'm going through this theory in quite a fast track because we have limited time, and I want to go through like the fundamentals of each topic so that you are in the mood, so to speak, of criminal law. Before we look at a question briefly, and then I'll go through the questions that you're having as well. I do see that there are a lot of questions coming in as well, so bear with me. We'll try to make this as short as possible so that then we can go directly into questions. Right, having said that, involuntary manslaughter then becomes a situation where once again the actus reus, the physical act, is complete, but there is no requisite mens rea. You could consider that there's no mens rea at all for that matter. What that means is, if you consider things like gross negligence, where a doctor may have performed his act or may have performed his duty below the reasonable standard expected, thereby breaching his duty and causes death. You could argue that he doesn't want to kill this person, but his actions have led to it. This is involuntary manslaughter by gross negligence. A situation where you know what you're doing is dangerous. You never had the intention to kill anyone, but you know that it could lead to that. This being recklessness would be complete by involuntary manslaughter by recklessness. Or you're doing some sort of thing which is illegal, which is unlawful, which inherently is dangerous and causes the death of the person. This is essentially unlawful act or constructive involuntary manslaughter. Now, all of these things, the reason why I'm saying it in this context to you is because to substantiate the fact that definitions are key in criminal law. Everything is very specific. Everything is in relation to each individual component of the definition, and the absence of even one part of it would mean a complete acquittal where you get to go home as a defendant, or it might be a mitigation. Just like we mitigate murder to voluntary manslaughter, or just like we try to reduce sentences by virtue of saying that something in the actus reus, or rather something in the mens rea, is missing. Generally speaking, the absence of actus reus amounts to no offense whatsoever. You need to have a physical act. This combination of the two is what leads to ultimately looking at the complete offense being complete. You can still have attempts, so to speak, but nevertheless. Right, so I'll proceed on, I'll move on so that you have a broader understanding of the different topics before we go into a question. Now, similar to homicide, similar to the offense of homicide essentially, we have the next level, which is a step below, I would say, of common assault and aggravated assault. Now, common assault and aggravated assault, I'd like to consider it as being somewhere a step beyond that of like a property offense as such, where you still have an attack or you still have some sort of interaction with the person, with the individual, but the situation or the outcome is not that of death. It is rather only that of some sort of injury, either fright in the case of assault, some sort of force in relation to battery, or injuries when it comes to things like section 47, where it's actual bodily harm, section 20, where it is wounding, where it's a break in the continuity of the skin, or section 18, which is that of grievous bodily harm. The only difference between section 18 and that of murder, as I like to consider it, is the fact that the victim is still alive. Some may even coin and couple section 18 offenses as that being very similar to attempted murder, where almost everything except for the final act, the final result, is missing. You have essentially taken the person to the brink of death, but the final act has not been complete. Similarly, when we go through different areas of offenses such as, for instance, theft, which amount to property offenses, all of these things are elevated in relation to different aspects. So if you take offenses like theft being the primary base foundation of it, essentially the dishonest appropriation of property belonging to another with an intention of permanently depriving the other person of it, you'll notice that this offense is fundamentally accomplished when there is appropriation, which means you take or you do something that which only the actual owner could do with the property. It is tangible in nature and it belongs to another person. Usually when it comes to the fundamentals of theft, the most difficult aspect to establish is that of dishonesty. How do you maintain and establish dishonesty? You'll notice that I'm somewhat considering all of these in their fundamental building blocks. The reason for this is because when you think about different types of offenses, every single element matters. I can't stress this enough. What most students lack in terms of their articulation, in terms of examination answering, is the fact that they take definitions broadly. They just look at homicide and say, okay, it's murder because of X, rather than considering the facts themselves and seeing if something or the other is missing. Now, having said all of that, we can think of the different offenses as being vital to establishing our arguments as well. So if I can just proceed here real quickly, just like the aggravations here of robbery and burglary, where we look at, for example, the attempt or the actual offense of theft itself substantiated or added with force, or burglary, where it's theft or any other offense while being a trespasser. So you'll notice all of these things are like building blocks. Every element can be aggravated further in some way, shape, or form. Now, I'm not going to go through extreme detail of each individual one. We'll try to formulate a schedule in which, for those of you who are interested in theory lessons, there's plenty of content on this channel itself, plus on my online platform that you can have access to have a look at, and the links will be in the description to this video as well. But we'll come to the creme de la creme, which is essentially the Q&As, because I did notice that there are a lot of questions coming up. So let's try to go through each one at a time. Let's try to get these questions into one place so that I'm able to have a look at as well. Okay, let me put this here. Okay, so a few questions here. Let's have a look at. Okay, so I have one question here which talks about ulterior acts rear. I'm not quite sure what you are trying to get at. I believe what you're trying to suggest here is in relation to oblique or indirect intent, or ulterior motive as such, although motive is not something which is essentially quite important when it comes to criminal law, because we deal primarily, when it comes to the rationale or the reasoning of something, we don't really focus a lot on subjective elements, so to speak. So if you are asking me the question of what is ulterior intent, or if you're asking me about oblique or indirect intent, this comes specifically important when you think of a situation where, take for example, a particular type of offense, such as murder. So murder is something to the effect of an unlawful killing of a human being with an intention to kill or cause grievous bodily harm. So as the mens rea requirement, the mens rea component must be an intention to kill or cause grievous bodily harm. If this aspect is missing, what that means is it's not that you can't charge the person. It means that you can't charge the person for murder. It might be a lesser offense. It might be voluntary manslaughter by either diminished responsibility or loss of self-control. It might be even involuntary manslaughter by recklessness, for example. If it is subjective in that context, if it's not exactly intention, that is the problem. So when you say oblique intent, it is a situation where you'll be able to substantially charge the person with murder, whilst the person that died wasn't the person he wanted to kill. So for example, let's say I point a gun at you, at your head, and I say, John, I'm going to kill you. And I fire it at your head. It penetrates, it kills you. I have now committed murder. Simple. But presume that I point a gun at you, I say that I'm going to kill you, and as I fire, you duck. There is a person standing behind you, and that person gets shot and killed. Now you could argue that the actus reus is complete. because I have unlawfully killed a human being with an intention to kill or cause grievous bodily harm. But the intention to kill or cause grievous bodily harm is not in relation to the actual person I want this to happen, someone else. So if I am to be charged with murder, you need to establish oblique intent or an indirect intent, which means it's transferred malice. You would have heard of this term as well, where what I wanted to happen to you gets transplanted onto the actual person that died. I hope that's clear. Let's see if there's something else that's connected to that question. Okay. So in that context, I think what you're suggesting is whether there's a causal gap. There's not an intervening event as such, but the outcome is not the same as what you anticipated it to be. So this is circumstantial. It depends on different situations. So let's say, for example, like the example you're giving, you slap a guy, but he dies. It's a very extreme situation. But what's missing here then is the mens rea component. So you can't charge the person for murder because clearly he didn't want that person to die. However, you might be able to charge him with something like involuntary manslaughter by recklessness, where, while it's unlikely, where the act itself was dangerous and may cause the death, he doesn't want that to happen, but he does it anyway. So his actions have fit the actus reus, but not the mens rea. I hope that's somewhat clear. What else? Yes, this video will be recorded. This can be replayed later as well. Hopefully, this is the first time I'm going live on this platform though. Okay, so we have a question. When attempting problem solving and essay questions, what method or technique to follow? Now, different students, that's a good question. I think that brings us to a very good point here. Different students look at answering questions in a very different manner. Now, fundamentally, I would always argue that problem questions are very much mathematical. What I mean by that is problem questions are structured in a way that it provides you with an opportunity to pick a side and go for it. This is why you would notice directions in questions such as advise John or advise the parties. What problem questions mostly expect and anticipate you to do is to position yourself like an advocate, like a lawyer. So fundamentally, you pick a side and you go for it. Now, generally speaking, when it comes to a well-crafted, thoroughly outlined response to a problem-based question, what I always recommend is to have a very comprehensive introduction. So your introduction should have 3 elements. Once you've gone through the question, your introduction should firstly have the parties and their relationship to one another. So if it's a criminal law question, for example, it should show who the victim and who the defendants are, whether there was anyone intervening in that action, and so on. That's the first part of your introduction. The second part of your introduction should indicate the primary and secondary areas of law that you're going to talk about. So, for example, imagine a situation that relates to homicide, specifically murder, and maybe the question whether there is a mitigation to voluntary manslaughter by loss of self-control. There is an indication in the question that the person has been seriously wronged or there was serious violence and then he snapped. So you would include things like, as primary areas of law, homicide, specifically that of murder, and the possible mitigatory defense of voluntary manslaughter by loss of self-control. That's the second part of your introduction. The third part of your introduction would be the fundamental issues that have to be tackled. So every question will have 1 or 2 major problems that have to be looked at. It might be that the actus reus and the mens rea of something doesn't match. It might be the fact that the mens rea is questionable and it might be one way or the other. Some questions are formulated, for example, in homicide where It may be loss of control, it may be diminished responsibility, it might even be insanity. So this distinction is important. Sometimes there might be a third party that has intervened. This happens a lot when it comes to OAPA, or aggravated assault questions. So that is your introduction, and your introduction should be very chunky. It should have like 1 or 2 paragraphs. I always recommend this. It's like a abstract to a thesis. The rest of your response should essentially be you breaking down the fundamental issues, that third part of your introduction. That is what you should break it down to. And most of these responses should be something like 750 to 1000 words or so. Now, when it comes to essay questions, the situation is slightly different. For essay questions, the primary requirement is that you need to show the examiner that you have understood and interpreted the question in your method. So you know that essay questions are always like in very short form. I always say the shorter the question is, the more difficult it is. So when the question is short, it's up to you to interpret these questions. And the introduction should literally be your breakdown on what you understand from it. A good rule of thumb is to start an essay question by saying the following essay in some way from your perspective, but the following essay invites, or the following question, this essay question invites us to consider X, Y, and Z. That's your interpretation of it. And then add to that your structure, how exactly you're going to tackle it. Always go for the unorthodox response. I hope that clarifies a bit in terms of how to structure, how to go about questions. Since there's a lot, I'm going to move ahead. I'll come back if there's something that's missing. Okay, so there are a few questions here. Let's see. Okay, so if a 14-year-old purposely glasses his sleeping dad, I'm not sure what that refers to, but okay, who has a history of abusing his wife, would the child be liable for indictable offenses, or be saved by defense, or be rebutted? Okay, so two notions there, right? So one is, again, 14-year-old, so that would mean that there's a problem when it comes to capacity. Generally speaking, and this might be different based on the circumstances here, if it was an immediate reaction to something, there might even be based on the circumstance, there might even be a defense of self-defense, if you are really trying to put that into the mix. If not, I'm not sure if you've heard of a case called R and Aluwalia, which originally was decided on diminished responsibility, but then later on loss of self-control. There was a principle that was established called the battered woman syndrome. So the case, the shorter version of the case is basically a wife. A wife was essentially looked at in a very deprecating manner by the husband, was constantly abused. She was made to feel worthless. He would come every night and say that, he's having an affair and things of that nature. And over a number of years, this essentially affected her psyche. It affected her mentally. And one day she decided to kill him, but not in that context. She set fire to his bed, and he later passed away in hospital. So the principle here was whether it amounted to loss of control now, provocation, which was the offense back in the day. So she ultimately got out on that, but I would consider here also it's the opposite of that. Self-defense is more likely depending on the circumstance. To be fair, the information is insufficient to establish one or the other. I'm not okay. It says glasses means scratch with glass. Okay, so there's no killing as such. In that case, there's no self-defense or loss of control. Yes, that defense would be applicable there in the sense that there is capacity. The fact that she was the child was trying to protect the mother. I hope that's somewhat clarifies the outline there. That's quite a convoluted scenario though. Okay, how do we decide on to charge for recklessness or intent? When R.M. Matthew loves second stage sane as intent. Okay, so I'll tell you this in the general context because it's important to understand the value of intention and recklessness. So these are thresholds, right? In terms of the requisite mens rea, they are thresholds. Intention is the highest threshold. So if you take it in the context of the mind, intention in law refers to the fact that you know what you're doing, you know what the outcome should be, and you do it because you want that outcome. You know who it should happen to. So you know who you want to do this to, you know what you want to do, and you know what you want to happen, the outcome. That's intention. Recklessness, you can think of it as missing two of these three elements. One is you are not specifying a particular person. So you don't know exactly who you want to do it to. You're not planning on one particular person. You don't want the outcome to happen either. The only thing is you know that the outcome is likely. So as long as you know the outcome is likely and you proceed on to doing it, that amounts to recklessness. So whenever you have an offense that requires intention, the definition of that offense suggests you need intention. It can't be anything below that, which means anything that is less than intentional cannot amount to that offense. Doesn't mean this person can't be charged. There is a question that I often get from my students. Does it mean that if you don't fulfill that offense, that's it? No. Plenty of offenses are there in statute and in common law where the outline is there is another offense that is lower. I mean, even for murder, there is a mitigation of voluntary manslaughter or involuntary manslaughter at that. So similarly, the threshold when it comes to recklessness means that if you have intention, that's just one better. Your sentence can be made higher essentially. Okay. Okay, so there's a question here, how to differentiate between murder and constructive manslaughter as both result in death. Is it the difference of mens rea? Correct. It's actually the absence of mens rea. So if you take the three offenses that come under homicide, where a person has died, so homicide would be made up of, the category would be made up of murder, voluntary manslaughter, and involuntary manslaughter. So the way I put the equation down is murder is actus reus plus mens rea of murder is unlawful killing of a human being with an intention to kill or cause grievous bodily harm. The same exact thing is what's applicable for voluntary manslaughter, unlawful killing of a human being with an intention to kill or cause grievous bodily harm. Conditions apply. So what that means is something has qualified the mens rea. Something has made something has created a doubt essentially as to whether his intention is absolute, whether there's no questions regarding that. Involuntary manslaughter is unlawful killing of a human being, which is the actus reus component, the physical act, and technically no mens rea. It is either the fact that you have failed in your duty, which is gross negligence, that you did something which could cause the death and did ultimately cause the death, but you never intended that to happen, recklessness, or you are in the process of doing something unlawful, let's say burglary, and in doing that, you have the intention only to do that, but as a result, it goes on to killing someone. So that's constructive or unlawful act manslaughter. So you're right, the only thing that's different here is the mens rea, the lack thereof essentially. Okay, what defenses are available for constructive and gross negligence manslaughter? The short answer to that is technically none. The only way, because think of it this way, right? These are all fundamental building blocks. When you take any type of offense, the offense is built on the actus reus and the mens rea. A complete acquittal will only be possible if both of these elements are negated. One way that both can be negated is automatism, where the establishment of the fact that your actions are involuntary means that the actus reus component is completely negated. Now, having said that, can you have a defense for gross negligence manslaughter? Perhaps, but it's not straightforward in the sense that the fact that it is already gross negligence means that there is no need for mens rea. So you shouldn't have then done the actus reus at all. Your sentence might be reduced, but it doesn't negate your charge. If you're asking in terms of defense whether there is a possibility of having a complete acquittal, no. Okay, did I miss out on any questions? Anything that I have not gone through? And any other questions that you want me to go over? If not, we can wrap up for our very first criminal law session. I was expecting a little bit long, actually, that there'll be more questions that are posed as well. Okay, let me just get this up real quick. Right, so if there's no more questions, if there's nothing further that you want me to clarify in terms of criminal law, I'm hoping to have more sessions of this caliber because we're at a very different. Oh, there's one more. No, there is no intention at all. Yes, that's right. So in involuntary manslaughter, so the question is, so in involuntary manslaughter, there is no element of intention. No, there's completely nothing at all, because the whole premise of involuntary manslaughter is your actions were involuntary. Did you do the outcome, or did you cause the result to happen? Yes. Did you want the result to happen? No. So that component of did you want the result to happen, which essentially amounts to the mens rea component, is missing. It has happened by happenstance, so to speak. Either the fact that you owed a duty to either safeguard or not do something to harm, and you acted below the reasonable standard, which amounts to breach, and that caused the death. That's gross negligence. So there is no intention component there. It's similar to that context essentially. Okay, so if we are all good, or is there any more questions that you would like me to go over? Anything at all that you'd like me to answer? And hopefully we'll be able to do much more of this over the next coming set of weeks. It is quite a trying time in terms of, not just in terms of law students, but in terms of every other aspect of the world as well, globally. So because of that, I want to try and create a platform that we can have discussions of this caliber. Hopefully we can have a system where we'll be able to discuss back and forth as well, and not limit ourselves to the chat boxes. But apart from that, if you found these sessions useful, I'd very much like more feedback on them as well, so that I can improve for the upcoming ones also. Okay, one final question, I believe, before we wrap for today. So the question here is, when providing advice to the client, whether we are to mention definitively that whether they have breached something, or to sort of track around that, to hedge, so to speak, and whatever that has been. In other words, whether you're asking me whether it's a situation where you should be indifferent to what has happened. I would always argue to the latter. The context that it is non-essential when you're providing advice whether they have done it or not. The idea is to look at the circumstances that has presented themselves, see what best you can do to provide a mitigation for it on the one hand, which means to reduce it if there's no way of getting out, or at best to acquit or get the person out of the picture. So whether you are going to, in definitive terms, tell your client that this has happened or not is technically irrelevant. It's a redundant, it's a moot point at that. Okay. Thanks once again for joining me for the very first session. There'll be several sessions on different subjects as we go along in the next coming few weeks. I'll be able to get this platform up and running in a better sense sooner than later, hopefully. But until such time, please make sure you provide some feedback on this channel as well. Make sure you check out the Law Simplified's online law school, which is accessible through courses.thelawsimplified.com. The links are in the description to this video. There are loads of sort of rich content there when it comes to pre-recorded masterclasses, to workshops, to spider graphs and case summaries and the works. And if you do want to reach out, there's a WhatsApp number on the description, as well as my email address as well, that you can reach out and we can discuss further. But thanks again for joining me. And as always, have fun and especially stay safe. And as always, obey the law. Thanks a lot, everyone.